off. The thumbnail picture's even worse than usual. What can you do? You gotta like lose for thumbnails. Trying to hold up the book, and it got me like halfway there.
You should do a selfie for the
Oh no, you're sitting there. Okay, all right.
I mean,
It's fun. Over here, is that okay? Yeah. Let's see. Oh no, I gotta move this over. Going well.
they have what are their main cats? Let me see. That cat looks so funny. One of their main cats is a.
I said, are you coming?
Listen, yesterday, what was it? Yesterday was just a rough day.
Yeah.
But
You didn't miss anything.
well, when he said he was like, get the no, I was like, oh gosh.
Forgive me for cramping.
Oh no, it's okay.
Yeah, we'll explain it to you.
Yeah,
I got destroyed at one point, husband.
really?
Yeah, for leading.
Oh, well, that'll do it.
Why? Nobody's ever taught me what it is and what.
That's what happened yesterday or on Monday when I had no idea what I was doing.
Yeah, I'm like, sorry.
Yeah, I had it, and it's the thing is it's a procedural thing. Like that's something that you can lecture us on. That
Yeah.
isn't learning through mistake, you know.
I'm gonna tell him we need some type of lecture.
Because when he lectured us on Monday, that was really helpful. Or
Yeah.
maybe not Monday, we got early, but it was Wednesday. Remember, like we got done and he just like spent 30 minutes lecturing.
Yeah.
That was fun. Like not fun, but like helpful.
Yeah, we need more lecturing.
Yeah.
Trying to bond with the cats.
Oh, sorry. Show me. No, you have my undivided.
You need to get your No,
It's like yeah.
So I could get you that tonight.
These are
He needs one.
they're married.
And you love them.
My sister, that's my sister.
I just want to the weekend sometimes. The longest I've gone was 4 days.
Yeah, I should.
That was by accident.
I've been sick and finally somewhat over it.
Oh yeah.
I'm like, I didn't have to take my daily medicine.
God, I like that hat.
Yeah, I was telling Rebecca,
I hit this.
grow my hair back out.
You are? Like long? Or your beard?
I mean, just both.
I've never seen you long. What?
I'll see how.
Hey, you are in Orlando. No one here for 3 more months like blue enough one.
That's what I said, but, like, I want it like down to like maybe like.
Where you can just like
I mean, I want long hair.
do it.
Well, I mean, it's gonna take.
Not letting them have to
Well, that's what I said. I got some fun.
I'm dead.
Look, help me. I'm looking for help. Who will help me?
You need to.
I want the
Technical?
technology to work today.
Oh,
Yeah.
You're looking at the wrong
Yeah.
person.
So someone visit.
Oh,
Might have
yeah,
been born
I'll
with
check it. I thought you meant
technology. I did
magically fix
No, I'm just, I presume it's going to work. I think I've done all the things necessary to make it work. I would just like to know before I start talking that it does work. If you don't mind testing.
It says, thanks for joining the presentation. We will be with you in
We're
just a
still-
moment.
Oh, that's a good sign. Now, if I flip this
Wait,
slide,
flip
you should get the question there.
No, we didn't.
It's still broken.
That's what it did last time.
It's still-
Hang on, because I looked this up last time. This happened.
Scott, you're in the wrong profession.
No, I was wondering. It says like, I mean, it says like if you're looking, like, is it open? Like I read this like last class, but it says like, is it open? Because I really tried to what it says. It's like, is it actually?
I know.
We used to have the.
I made a mistake.
It says open.
I'm down.
Oh,
Maybe.
Yeah, that works.
Oh, there they are.
It's all here.
But is that?
Coming.
Oh.
But it's changed.
Wait, when you click it, it pulls up the question.
Yes,
Hold on. You gotta maybe you gotta group them.
I'm having a seizure.
yeah, but they're
Look.
different.
But I've seen those.
Oh,
Oh.
I think it just.
Oh, wait, it came up on your screen.
Yeah, well,
Yeah.
everyone you click comes up here.
Yeah, every time you click it, it pops up, so you might wanna go up to the one that you want today and just click it.
I've got a lot.
How do I get it?
There you go. Now you got grouped them.
Yeah.
Group them.
This is all the questions
It's
for
coming
today,
up. It's on.
or these are all the polls for the whole class.
Yeah, like.
I'm so confused
What's your favorite?
because I'm trying to do the what's your favorite color one.
I can get that one.
I will.
When you did, there was one that was like, what's your favorite color?
Okay, there are a lot of now. Maybe that helps.
I'm gonna answer this question.
This
Oh, I don't.
Hopefully when it's done loading, it'll work. Okay. Anybody on the screen? Still with me on this testing? Thank you, thank you.
Yeah.
Can you,
Ooh.
There it
Oh,
is.
it's working.
it worked, you
Wow.
fixed it. Dude, thank you. I don't know that I would have ever figured that out, so thank you. Yeah. All right. Okay, this is nice, technology that works. It's my favorite kind of technology. Yeah, yours works too. Anybody else care to join us? Here's the screen if you want to play along. Because today's that class. Today's that class you were looking for. Today's that class where we play everybody's favorite game show, Name That Writ. You don't want to miss out on playing Name That Writ, right? Yeah. So go ahead if you care to join us. We're at PollEv, short for polleverywhere.com. P. McGinley 553, as I repeatedly warn, I don't know what the 553 means. Yeah. All right. So if you want to join us there, as you can tell, you can use this on an older model iPhone. Okay. So go ahead, try buzzing in if you like. You should be able to see percentages changing in real time. Oh, yeah, real time. Yeah. Back. So my test question, should the profession of law ever be viewed as a business? There's no wrong answer. It's a matter of opinion, right? Can't see the last one? Sure, yeah, no problem. So some of you say your opinion is D, some of you say no, it is unprofessional to do so. About 3% of you say no, clients must always come first. Hard to argue with clients coming first, right? Except for today. I'm signed up a new case literally last night. I'm working on a filing due today. And little Madeline, she's a cheerleader, in the first grade. And St. Margaret Mary, her school is having a pep rally. So I almost made the wrong decision. I almost stayed at the office working instead of being at the pep rally. But I came to my senses, got my opposing counsel on the phone, was as charming as someone like me can be. They agreed to an extension of time. How long are you looking for? They said. Anything you'll give me, I said. My daughter's pep rally is in an hour. I'd like to be there. So they gave it till Monday. That's all right. Today's Thursday. That's Monday. That's plenty of time to get to the pep rally. Thank them. So yeah, client must always come first. But how about when your daughter Madeline's at the pep rally? Should they come first then? Right, family first. Yeah. 10% of you said yes, but only for certain types of legal matters. Should the profession of law ever be viewed as a business? Yes, but only for certain types of legal matters. That's interesting. I won't call anybody out. Anyone want to volunteer that they were of this 10% and that was their answer? They want to share why? Don't have to if you don't want to. Yeah, okay.
Well, that's just when it comes to legal matters that are way more personal to the client, so will certain issue managers say I think certain property matters should be like in a business entity setting. So
Yeah.
just
Well, I respect that.
personally to the client.
Okay. So you see certain legal matters as different than others when it comes to whether or not to run it as a business. All right. I respect that. Yeah. And 77% of you, and I got to confess, I probably would have picked A also. Yeah, 77% of you, yes, lawyers must earn a living too. So I guess there's that old cliche, when you're on an airplane, it's about to crash. Let's hope this never really happens. They always tell you to put your own oxygen mask on first so that you can help others get their oxygen mask on. You know, what's the lawyer who can't earn a living? How's she or he supposed to help another? You know, none of us are free of problems. None of us are problem free as lawyers. But if we're too overwhelmed by our own problems, how are we supposed to have the time, energy, even the mental focus to help others with their problems? You know? So I don't know. There's no right answer here. There's no wrong answer among them, but there's different reasons why you might pick different answers. But I you know me by now, I have a very romantic view of the lawyer, don't I? And maybe you do too. But I respect lawyers. I love lawyers. Have I met some lawyers that are hard to love? Oh, yeah. I guess we all have and we all will, right? But yeah, I don't see a problem with the profession of law having its business side. One of the things we studied was the Florida Civil Rights Act. And there, in an almost personal or private attorney general way, it created fee entitlement so that those who felt they were aggrieved in their civil rights and had an action under the Florida Civil Rights Act could find a private attorney of their choice who might take the case on a contingency, hoping to win fee entitlement. That's one of the ways I think a law can balance that problem between the lawyer needs to earn a living too, and the lawyer needs to serve the community. The lawyer needs to put the client first, right? So there's a balance there. And for each of us, we've got to reach that balance in our own private practice. So maybe you've signed up a great new client, can't wait to help them. And at the same time, your daughter's got a cheerleading pep rally, can't wait to be there. You got to find that balance. So my prayer goes out to you that whether you're a law student or whether you're a lawyer, find a way to find that balance. And that balance is there. That balance is hard to keep. You need some sort of strength and a way to help you find that balance. And you know what I'm going to suggest, don't you? I wear it on my sleeve, don't I? Got these sleeves hemmed all the way up here because I always wear it on my sleeve. For me, it's the church. The church helps me keep that balance. Do I get it right every time? No. I was a little late for Alan's pep rally, for example. But hopefully you'll get it right and I'll get it right. We'll all get it right. That's my prayer that goes out to all of us today, that we get that right. So if you care to join me in the name of the Father, the Son, the Holy Spirit, amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Remember, O most gracious Virgin Mary, that never was it known that anyone who fled to your protection, implored your help, or sought your intercession was left unaided. Inspired by that confidence, I fly unto thee, O Virgin of Virgins, my mother. To thee do I come, before thee do I stand, sinful and sorrowful. O Mother of the Word incarnate, despise not our petitions, but in your mercy hear and answer us. Amen. In Father, Son, Holy Spirit, amen. All right, I left you last week with a burning question. That burning question is, why do I dare to suggest that in the case of Florida and the Supreme Court of the state of Florida, that Florida's Supreme Court might be somewhat less than supreme? Perhaps even you might jokingly say that it's a misnomer to call it Florida's Supreme Court. That question will be answered in due time. I will allude to the answer as we go along. And one of the ways I might allude to the answer is this question right here. That comes after I note this part of Article 5, Section 15 of Florida's Constitution. We talked about it last week, right there toward the end. The Supreme Court of the state of Florida shall have exclusive jurisdiction to regulate the admission of persons to the practice of law and the discipline of persons admitted. In other words, us. Oh, can't forget. I'd be honored to know who was here. So here's the attendance sheet. Yeah. Pen and paper. There you go. All right. So what exactly does that mean from the perspective of federalism? What does that mean from the perspective of federal law. Let's look at a question like this, for example. Just a hypothetical I made up. But Johnny never went to law school. Johnny wants to call himself a patent agent, but Johnny's not a real good test taker. Johnny flunked the patent bar. The U.S. Patent and Trademark Office hires Johnny after that as a patent examiner. 4 years later, Johnny quits the USPTO, and then he follows the rules for former patent examiners that you can find, if you wish, at 37 CFR section 11.8. By following those rules, Johnny obtains the title patent agent. That's the same title that Johnny would have earned 4 years earlier if he hadn't flunked the patent bar. So Johnny still has not passed any sort of bar exam. He moves to Florida. He opens his own office. He advertises. He gives legal advice to patent applicants. He drafts up patent applications. He meets and argues with the United States Patent and Trademark Office over denials, etc. Here's the question I ask you. Can the Florida bar shut down Johnny's office? Florida bar shut down Johnny's office. Whoa, a 50-50 split. Whoa. Oh. Leaning towards yes. Leaning towards yes. Oh. I hate when the majority of you are leaning towards the wrong answer. But you might change your yes. Yes. I was mistaken. The majority of you are leaning toward the correct answer. Yes, indeed. More than 80%. Come on, more than 90%. Just about all of you have got the right answer. B is the right answer. Why? We just looked at Article 5 of Florida's Constitution. It said that Florida's Supreme, got it, quotes, air quotes, Supreme Court is supreme in these matters. Why couldn't Florida Supreme Court shut down Johnny? Who can tell me the answer? Come on, you all got it right. Certainly somebody wants to share with me why. Yes, share with us why.
Because he followed the rules for former patent people.
Yes. Yes, he followed that rule. I had it on the site a minute ago. Was it 37 CFR 11.8, something like that? Yeah, he followed the code of federal regulation. But McGinley, it's in the code of federal regulations. That contradicts Florida's Constitution. Who wins? Yeah, it wins. It wins. Yes. Yeah, Johnny's calling himself a patent agent, right? But if you look at the fact pattern, he's doing a lot of things you and I might call the practice of law. The answer is not that Johnny isn't practicing law. I think one could effectively argue that Johnny is practicing law under this factual hypothetical. Is that where you're going with your
I
comment?
guess my question is
Yeah.
the rule for former examiners in order to obtain the title require that you actually have to be an examiner?
Well-
To be an examiner, you have to pass the bar.
Yeah, as I understand the USPTO rules, you could pass the patent bar and then you would have that title, where the title go, patent agent. Or if you were a former examiner with at least 4 years of experience, you could get that title by meeting the other qualifications, but without having to pass the patent bar. That's my understanding of those rules.
Because I was under the impression of the agent, you would have to get examined for 4 years before this.
Yeah, I think that's what the rules say. But the point here, the takeaway, the lesson to be learned is that federal law authorized this activity. And yes, you might conclude that this kind of activity, opening an office, advertising, giving legal advice to patent applicants, drafting up legal papers, patent applications, meeting and arguing with the United States Patent and Trademark Office over denials, in other words, litigating, you might argue that filling out legal forms, litigating, giving legal advice, running your own office, looks like the practice of law, and I think you would probably be right. What if federal law authorizes the practice of law? Then it's authorized, correct? So this Supreme Court of ours here in the state of Florida might say we might say in our state constitution, that is the only arbiter of these things, but yet federal law could say otherwise, right? And we remember that from our discussions. So let's look at that again. Let's take another angle on the same issue. Sally never went to law school or college. Sally dropped out of high school, but now she has a GED. Good for her. After meeting the requirements of the Internal Revenue Service, the United States Internal Revenue Service, she is given the title enrolled agent. Anybody know an enrolled agent? Talented people, great people to get advice from. Sally, enrolled agent, moves to Florida, opens her own office, and gives tax advice about the tax law to clients about how to minimize their future tax bills. When clients are audited, Sally meets with the IRS on the client's behalf, and Sally argues to the IRS on behalf of those clients. Doesn't like the outcome, then Sally will appeal within the IRS if her arguments are rejected. What if that doesn't work? Well, if that fails, Sally uses her membership in the United States Tax Court in Washington, D.C. to sue the Internal Revenue Service on her client's behalf. Sally is not, N-O-T, not licensed to practice law in the state of Florida. Under these hypothetical facts, can the Florida bar shut down Sally's office? I'm only fooling 16% of you. 12% of you. No, the Florida bar cannot, N-O-T, cannot shut down Sally's office. Why not? Same answer as before. She is an enrolled agent under federal law. Federal law says that she can do those things. Federal law preempts. She can do them. Before law school, you might have thrown around the phrase unlicensed practice of law, but now that you're a law school graduate, it's unauthorized practice of law, because Sally in our hypothetical and Johnny in our previous hypothetical, they may not have a license from the state of Florida or any other state or the District of Columbia or any of the territories of our nation that is a license to practice law, but they certainly have authorization to practice law. In Johnny's case, it was from the USPTO. In Sally's case, it was from the Internal Revenue Service. In both cases, it was an authorization under federal law, which preempts state. So here's the ultimate question for you law students. Here's what I want to ask. Who owes more in student loans, Sally or you?
I can answer.
Don't have to answer if you don't want to. But you see my point. There's more than one way to skin a cat. May God forbid any one of you find it impossible to pass the state bar of your choice. May God forbid that. Seriously. But if God forbid that were your fate, there's more than one way to skin a cat. Enrolled agent, patent examiner, many ways to essentially practice law. But I digress. I'm here to make sure you pass the bar exam of your choice, not find an option if you never can pass. But I just wanted to point that out. So Supreme Court of the state of Florida, maybe not so supreme, right? Maybe not. One of the ways it's less than supreme is the fact that there is federal preemption. Is there not? Of course there is. Now, this is something I hope to go through quickly because I hope it's a waste of your time. Different legal research and writing classes in different law schools do a better job than others when it comes to understanding Florida state court system and how case law precedent works in our Florida state system. I'm sure in your law school here, none of this is new. I'm sure that you know it like the back of your hand. Indeed, if you're going to practice in the state law system here in Florida state courts, this is something that's going to have to be second nature to you. You're going to have to understand these basic concepts. So let me see if I can just move through them in a rather quick way. But of course, I'm happy to slow down at any point that you want me to slow down, I'm happy to do that. So here's the problem. Some case law precedent is called controlling because its decision is enforced as the only permissible outcome. Other case law is called persuasive because it presents one possible outcome for the court to consider. The same case that is controlling in one court may be merely persuasive in another court. Anything news to you yet? No news. I'll keep moving. What is the solution to this problem I have presented? Understand the hierarchy of Florida state courts. That way you'll know when you've found controlling precedent and not just persuasive precedent. The hierarchy, of course, we have 67 county courts. Their orders can be appealed to a higher court. There are 20 circuit courts. Likewise, their orders can be appealed to a higher court. There are 5 district courts of appeal. Can we make the blanket statement under Florida state law system that their orders can be appealed to the Supreme Court of the State of Florida? No. No, we can't state that as a blanket statement. Supreme Court of the State of Florida often does not have jurisdiction, as we'll go into in greater detail as this particular lecture progresses. The Supreme Court of the State of Florida is a court of limited jurisdiction. Our Constitution in the state of Florida spells out exactly when the Supreme Court of the State of Florida can take jurisdiction to review a case. And that exclusive list does not end with some sort of catch-all, does not end with some sort of fluffiness that you can twist and turn based on machinations to get the result you want. Basically, either the Supreme Court of the State of Florida has jurisdiction or it does not. There may be some interpretation, there may be some facts to resolve to determine that answer. But the law is clear. The law lists specific instances and only those instances where the Supreme Court of the State of Florida has jurisdiction. That's different than the Supreme Court of the United States due to different uses under federal and state law of a particular extraordinary writ, a writ of certiorari. The vast majority of cases decided by the Supreme Court of the United States are decided based on jurisdiction that was granted in the Supreme Court of the United States discretion through their discretionary grant of a petition for writ of certiorari. The Supreme Court of the State of Florida does not, does not have discretionary jurisdiction to grant a petition for writ of certiorari. They don't have, in Tallahassee and Florida Supreme Court, they don't have certiorari jurisdiction. Instead, we have enumerated jurisdiction. Either the facts are properly interpreted to grant jurisdiction in that enumeration, or they're not. Well, if the Supreme Court of Florida doesn't like the outcome, but they don't have jurisdiction, well, I guess that's something they can talk about at a tea party or a poker game, but it's not something they're going to talk about in binding case law precedent, because they either have jurisdiction to review the case or they do not. But understanding our hierarchy of Florida courts helps us to determine whether there's binding precedent or controlling precedent. That was the issue that started this discussion. You remember that our state is divided into circuits. Each circuit has at least one, some have more than one, county within their territorial jurisdiction. If a particular circuit rules, then that is binding within that territorial jurisdiction. Likewise, our 5 state district courts of appeal have a territorial jurisdiction. Can we make the blanket statement of saying that a ruling from the DCA of that particular territorial jurisdiction is binding upon that territory? Yes. But we can also add that in many instances, it is binding statewide. In many instances, a ruling of a single district court of appeal under Florida's court system is binding statewide. How and when does that happen? Hopefully this is not news to anyone. So have I covered anything new yet? Good. All right, nothing new. No. What are the sources of controlling precedent? 1, prior case decisions of your appellate court, by which I mean the one with the power to review and reverse the decisions of the court you're in. Remember that map? It divides each district into a territorial jurisdiction. Where are we sitting at this moment? We're in Orlando, Florida. Where's that? Florida's Orange County. Where's that on the map? That's right about there. Whose territorial jurisdiction is that within? Florida's 5th District Court of Appeal. So one source of controlling precedent are prior case decisions of your appellate court, as we sit here in Orlando in Orange County, Florida. That would be Florida's 5th District Court of Appeal. But that's not the only source of controlling precedent. The other source would be prior case decisions of another appellate court of equal rank, but only when your appellate court has not ruled. Imagine, if you will, a case of first impression. The only court to have ruled on it was, pick one at random, 3rd District Court of Appeal. But your case is pending, again, pick somewhere at random, over here in Orlando in the 5th District. It's a case of first impression, meaning no district has ever ruled on it until the 3rd District ruled on that case of first impression. Is that controlling precedent? Is that binding only upon the 3rd District? No. That's binding statewide under Florida's state court system. That news to anyone? News to some. All right. Okay. So I cover this. It's all right. So let's put that to the test. Here's real world example number 1. You're researching whether your corporate client's in-house investigation report is subject to discovery by the opposing side. Your client's suit is pending before the 9th Judicial Circuit Court. Where's that? It's right here. It's in Orlando. That's in Orange County. Orange and Osceola, 9th Circuit. You find case law precedent from the 5th District Court of Appeal. Where's that? It's also right here. Physically, it's located in Daytona Beach, but you remember from the map that it covered many counties, including Orange County, including the 9th Circuit. You find case law precedent from the 5th DCA holding that such a report is indeed subject to discovery. Is this controlling precedent? Is it? The answer is yes. If we take a look at the map, we see that the 5th DCA has territorial jurisdiction to review and reverse orders of the 9th Judicial Circuit Court. That makes this precedent controlling. Okay? So there we are, Orange County. There we are on the map. That's the 9th Circuit, right? Overlay the other map. Here it is right here. Keep track of my fingers on it. Whoa! Whoa! Now I'm in the 5th Circuit. Keep my finger there. Keep my finger. Whoa! Now I'm back in the 9th. It's magic. It's magic. You see how it works, right? All right. Let's mix it up. Let's make it a little harder, maybe. Real world example number 2. Same facts as example number 1. Except this time there is no precedent from Florida's 5th District Court of Appeal. 5th DCA has no ruling on this particular issue. Instead, it's up in Tallahassee. It's the 1st District Court of Appeal. That is the only District Court of Appeal in Florida to have ever ruled on this issue. Is the 1st DCA's decision controlling precedent before the 9th Judicial Circuit Court in Orlando, or is it just persuasive precedent? You're correct. It is controlling. It is more than persuasive. It is the law that must be followed. Well, wait a minute, McGinley. It's the law that must be followed. I'm in the 9th Circuit. I'm in the 5th DCA. How'd that happen? How it happened was there were 2 sources of controlling precedent. There's your DCA, or there's decisions of other appellate courts. But only when your appellate court is not ruled, which is what my fact pattern included. So remember that burning issue I left you with from our last class? How can McGinley dare to say the Florida Supreme Court? Why does he be so bold to put supreme in air quotes? How could it be anything less than supreme if it's in the name? Their jurisdiction was limited, and issues of first impression are resolved statewide without their involvement. See that? See that? Statewide, without their involvement. One regional District Court of Appeal can create controlling precedent, binding law that applies statewide. Real world example number 3. Same facts as before, but this time there are 2 appellate decisions on point. One's out of Tallahassee from the 1st District Court of Appeal. One's out of Daytona Beach from the 5th District Court of Appeal. And don't be misled by me saying Tallahassee and Daytona Beach. Obviously, there's far more of the Panhandle than just Tallahassee that's covered territorially by the 1st DCA, right? And there's far more than just Daytona Beach and Volusia County that's covered territorially by the 5th DCA, including here in Orange County. So, under my hypothetical, the 1st District Court of Appeal says yes, and the 5th District Court of Appeal says no. which, if any, is controlling precedent here in Orange County, here in the 9th Judicial Circuit Court. What's the answer? It's on the board. The answer is yes. Go ahead.
It's the fifth because that's the closest circuit to us, right?
Yes, it's the 5th. And I would phrase it just slightly differently as to the why part. You're right. The why part is it's to use slang, it's your District Court of Appeal, or to be more technically correct, you are within the territorial jurisdiction here in Orange County in the 9th Circuit Court. You're within the territorial jurisdiction of the 5th District Court of Appeal, making it, in slang, your appellate court, making it binding upon this territory.
What if we weren't in the jurisdiction? So.
Oh, you're jumping ahead. That's like hypothetical number 4 or something like that. Let me put a pin in that. Gonna answer it. Gonna answer it.
That's what I was thinking. I didn't
Yeah, no, I want you thinking that way. You're thinking correctly. Yeah.
I just was guessing that because this is closer than
You guessed right. If it was a guess, I think you knew it. But if you guessed, then you guessed right. But I think you knew it. Yes.
Question, let's say they go with the 50 CA decision and then.
Well, they have to. It's controlling precedent upon the 9th Circuit because the 9th Circuit territorially is within the territorial jurisdiction of the 5th District Court of Appeal.
Right, and then it's appealed to the Florida Supreme Court and you just have these 2 decisions. Do they?
That's a big if. If it's appealed to the Florida Supreme
Oh,
Court.
it's gonna be appealed. I'm appealing to the Florida. Supreme Court.
Okay, you're the lawyer on the case. You're appealing.
I'm appealing,
Okay.
And so now does Florida Supreme Court have, they can go either way, right? Because you can argue.
Yes, first of all, Florida Supreme Court, if you are a lawyer on the case who can file a notice of appeal to Florida Supreme Court, you could argue that this meets one of the enumerated jurisdiction enumerations of Florida Supreme Court. You might argue for conflict jurisdiction. When there's a conflict between the DCAs, Florida Supreme Court, that's one of their enumerated jurisdictions. So you might argue for conflict jurisdiction. And yes, they will rule upon the case as they feel the law requires them to. They won't say, well, 1 beats 5, so if the first said it, then I got to rule with them, or 5's higher than 1. If the 5th said I got to rule with them. No, they're going to rule on the merits of the case, applying the law as they see it to be properly interpreted. If Florida Supreme, but put that in air quotes again, court has jurisdiction. Yes.
But they can say though, you know what, we think the 5th DCA got it right.
Oh, yeah.
So we're gonna, this is the way
Just-
the 5th DCA
yes.
decided it, we agree, and that this should be how all of Florida decided it.
Yes.
Or they could say, no, both of them got it wrong, this is what it is.
Yes, that's true. Because, and I'm agreeing 100% with you, just rephrasing it slightly differently. That's 100% right because in the question you're asking, if there was an acceptance of conflict jurisdiction to Florida Supreme Court, then the 1st and the 5th conflicting decisions would both be persuasive, not controlling. They would both be persuasive upon Florida's Supreme Court, but neither would be controlling. So yeah, just as you can with any kind of persuasive situation, you might go even a 3rd route and not follow either of the persuasive rulings.
That's why I mean, I was like, or they can just do whatever they want.
Yes, that's a great point.
They don't have to follow the
That's a great point. Yeah, that's a great point. So real world example number 4, same facts as before, but this time the 2 appellate court decisions on point come from these 2 courts, one from the 1st and one from the 4th. The 1st says yes and the 4th says no, which, if any, is controlling precedent before the 9th Judicial Circuit Court. See what I've done here? I've put you in the territorial jurisdiction of a DCA that is silent on the issue, okay? In the 1st DCA, which is not within your trial court's not within its territorial jurisdiction, they have one answer, they have yes. And in the 4th DCA, which again does not have territorial jurisdiction over your trial court, but they say no. So what you've got is the 5th, which is where your territorial jurisdiction is silent. 1st says yes, 4th says no. What's the answer? Which is controlling precedent? Neither. Neither. Both are persuasive. So we have a conflict, but we don't have a resolution. The 1st said yes, the 4th said no. You're not in the 1st and you're not in the 4th. You're in the territorial jurisdiction of the fifth. McGinley, what are you telling me? You telling me that the state of Florida might have different laws depending on where you're standing? Yes, that's what I'm telling you. That's what I'm telling you. How could that be? Well, let me turn that around. How could that not be? What's unusual about that? Isn't that true in our federal system too? We have appellate courts there, circuit courts. Federal system answers no. Why doesn't the U.S. Supreme Court speak up and resolve it? Sometimes they do. Sometimes they don't. Same thing here in the state. Yes.
Maybe you could explain, I'm not really sure why it's not binding, why the first.
Yeah. So why is it persuasive but not binding?
I thought rulings could be binding statewide.
Absolutely.
Issue of first impression.
Absolutely.
But
Yeah.
is it because the other district court also reviewed it and did not? I'm just confused.
No. Let me reuse some slides to try to explain why. Why was this the outcome? This is correct. This is correct. But why? Why is this correct? Well, what we've done in our, I'm reusing some old slides here. What we've done in our hypothetical is we've had the first, I'm way too short to reach Tallahassee, I'll try. The first, best I can do. First said yes, fourth said no, but you're not in the first because you can't even jump that high. You're not in the fourth, right? You're over here in the fifth. Where did Orange County go? There it is.
Oh, I
You're over here in
understand
the
that. The fourth said no.
Yeah,
So they did, okay, I understand.
okay, yeah. So what you've got is conflict. Now, when I'm standing in the first, if you're tall enough, then you're going to follow the first. If you're standing in the fourth, you're going to follow the fourth. But when you're standing in the fifth, the second, or the third, you've got an unresolved issue. And you don't have a binding or controlling decision out of the first or controlling decision out of the fourth when you're standing in the fifth, second, or third, and the first and the fourth conflict. Now, why doesn't 3 years later, 5 years later, 7 years later, somebody take this up to Florida Supreme Court and get it resolved? You know, tell us. Yeah, you're appealing, but you were appealing because you were the lawyer in one of the cases. Under the Florida Rules of Appellate Procedure, if you're not a party to the case, but you don't like it, can you file the appeal? No, you got to be a party to the case. Here's a harder one. You're a party to the case and you don't like it, but you missed the deadline. 30 days to appeal. Can't appeal. It could very well be that some party ran out of money, ran out of motivation, didn't want to resolve that conflict, for whatever reason, didn't meet the deadline, and left the state in an instance of conflict. Our system contemplates that. Yes.
I have a question. I understand some federal jurisdictions, the courts will allow what's called equitable tolling. There are equitable reasons for a delay in filing something. They'll equitably toll the statute of limitations or delay in filing.
Okay.
Does Florida recognize that concept as well?
Okay. That's a little bit afield of the point I wanted to make today, but it's a fair question. Essentially, your question boils down to, can I file a late notice of appeal? The answer is going to differ based upon the type of case. You may be able to do so in a criminal case. You may be able to do so in a case that involves termination of parental rights. You're not going to be able to do so in your usual case. You're not going to be able to do so in a civil case. In a civil case, if it's day 31 and you got a car wreck, your internet went out, you don't know why your laptop lost the thing, and you're trying to file on day 31, sorry. It's not a forgivable deadline under the Florida Rules of Appellate Procedure to try to file an untimely notice of appeal in a case that's not already on appeal. If the appellate court has already got an appellate case open in your case because your opposing counsel filed a notice of appeal, you can file what you might call an untimely cross notice of appeal. Likewise, your opposing counsel already filed a timely notice of appeal, might amend the notice of appeal. But if no one's filed a notice of appeal and it's not a criminal law case, it's not a termination of parental rights case, it's your ordinary civil case, too bad, so sad, it's a jurisdictional flaw that can't be remedied even by equities. Can't say it was not fair. Sorry. Question.
Even if, let's just say it was a really, really, really important appellate case, and opposing counsel said, sure, I'll let you file on the 31st day, and you go and you ask the judge, and the judge grants, like, you can't, there's no leeway for that either, for opposing counsel.
No.
Giving an order for a-
No, isn't that awful? So in your hypothetical, opposing counsel's even agreeable to file on day 31 or 32. But the problem is it's a jurisdictional flaw. Jurisdiction's either something a court has or doesn't have. So in that usual civil case, it's not a criminal case, it's not a termination of parental rights case, in that usual civil case, on day 31, even if opposing counsel has no objection, or even if opposing counsel stipulated on day 30 that it's okay for you to file on day 31, that stipulation is not going to create appellate jurisdiction on day 31. It's not something that can be done. Yeah. Question. Okay. Wasn't my goal to have an elaborate discussion about untimely filings of notices of appeal, but I wanted to answer the question since it was out there. So our point was there's two sources of controlling precedent. There's your appellate court, meaning the one within which your trial court is physically locatorial jurisdiction over your trial court still creates binding case law precedent for the entire state. Don't forget that. So that brings us then to jurisdiction of the Supreme Court of the state of Florida. Not so supreme, was it? Was it even contemplated to be the ultimate arbiter of these issues? One could argue it's contemplated that the district courts of appeal were supposed to be the ultimate arbiters, right? One could make that argument. And we can make that argument because, as I mentioned, there's a list. It's kind of dry and boring to go through the list. So I will talk as fast as I can as I go through the list. Okay. Jurisdiction of the Florida Supreme Court shall hear appears from final judgments of trial courts opposing death penalty. So they got the death penalty cases. And decision of the district court of appeal declaring valid a state statutory provision of state constitution. Question. What if the DCA is declared valid? Now does Florida Supreme Court have jurisdiction? Not under this, it doesn't. What if the DCA is not a question of firm beliefs? It's a question of whether or not you're on the list. It's kind of like the attendance sheet I just handed out. At some point, I'll hand that into the registrar, and either you were on it or you weren't. You might have a firm belief, even though you're absent, that you should have been on the list, but that's not going to help you. Right? Number two, when provided by general law, Florida Supreme Court hears appeals from final judgments entered proceedings through the validation of bonds or certificates of indebtedness, and shall review actions of statewide agencies related to the service of utilities, providing electric, gas, or telephone service. Real specific stuff, right? Number three, may review any decision of a DCA that expressly declares valid a state statute. Oh, maybe this one's going to make the list after all. Or that expressly construes a provision of the state or federal constitution, or that expressly affects a class of constitutional state officers, or that expressly and directly conflicts with the decision of another DCA or of the Supreme Court on the same question of law. That last one was the conflict jurisdiction we talked about, right? But what about the first one? McGinley, were you lying to me earlier? You said they have jurisdiction. If the DCA says it's invalid, and they do, they have jurisdiction. But they may, see the word may? They may, in their discretion, take jurisdiction if they say that it's valid. So, DCA said that law is unconstitutional. That's landed on the Supreme's desk. DCA says that it's constitutional. Supreme Court may, doesn't have to, may take the case. Same thing with the conflict jurisdiction. But the state's in conflict. Shouldn't the Florida Supreme Court have to take it? No. But they may. You could argue for conflict jurisdiction. But the Supreme Court might decide, we don't want to decide that. May review any decision of a DCA that passes upon a question certified by it. Certified by who? It, meaning the DCA, not the Florida Supreme Court. So the DCA holds the cards. Supreme Court, again, maybe not so supreme here. Love my air quotes. I'm going with the air quotes today. Yeah, I probably look ridiculous making air quotes, but I'm trying to make a point that you can remember. So they may review at the Florida Supreme Court a DCA decision that passes upon a question that the DCA certifies to be of great public importance, or that the DCA certifies to be a conflict. Here's a cool question. Must the DCA so certify? If it's a conflict, do they have to certify that? No. If it's a question of great public importance, this is your case, you know, well, this is a very important question, it's very important. Must the DCA agree with you and certify it to be of great public importance? No. Again, is the Florida Supreme Court so supreme? If the DCA, despite the importance of your case, won't put in the question, in the order, we certify this question to be of great public importance, then it's not something Florida Supreme Court can take jurisdiction over under that particular enumerated jurisdiction. 5, may review any order or judgment of a trial court certified by the DCA in which the appeal is pending to be of great public importance, or to have great effect in the proper administration of justice throughout the state, and certified by who? By the DCA, to require immediate resolution by the Supreme Court. In Con Law 1, in your federal con law, did you encounter a case where this happened? Anybody remember a case called Bush v. Gore? Ever heard those names, last names before? Bush, Gore? Yeah. These two gentlemen were running for president of the United States. You remember this? The Hanging Chad case, yes. So the trial took place. Then it was appealed to the District Court of Appeal. But they exercised their discretion. Supreme Court of Florida can't make them do it. The Supreme Court couldn't even make them do it. But they decided at the DCA that they wanted to do it. So they certified the question to be of great public importance and to require immediate resolution by the Supreme Court. So that's how Florida Supreme Court got jurisdiction in Bush versus Gore, if you remember that case. That case had to do with election law. And in a few moments, I will have an election law guest lecturer speaker to talk to you about election law under Florida and Florida's Constitution. So that'll be a little bit of a break for me running my mouth, but someone else will run their mouth. But that doesn't mean we won't play everyone's favorite game show named That Red. I know you want that. I know you want that. I'm going to come through. I'm going to deliver. But one thing I deliver is try to get through this list. All right. Whew. Question. You know the circuit court's judgment constitutes reversible error. You appeal to Florida's 5th District Court of Appeal. After all briefs and all argument are done, you get a one-page decision. 1 page. The top of the page is plaintiff or appellant's name versus, now we're in the middle of the page, defendant's name or appellee's decision, right? Then smack dab in the middle of the page is that line with the slash going this way. Why you got to have that line with the slash? You got to have that. And then after that, there's just 3 words. Who speaks that? All you've got wanted reversed. All you got is 3 words, per curiam affirmed. Client's mad and has money. Client says, I'm so mad, I'm going to give you money. Let's appeal to Florida Supreme Court. Can you do it? It's called a PCA, per curiam affirmed. You've been PCA'd, as the practitioners will say. Your case is over. It's over. Is there a certified question in those 3 words? Per curiam affirmed. Which one was the question? All right, this part's Latin. I don't speak Latin, but it ends with a period, so that's probably not a question in any language, right? Then you got affirmed. I speak English. That's not a question. It's got a period after it. No great public importance. No conflict there. Where's the conflict? It's not on the face of the opinion. So you have no way. That's how a DCA will shut down your case if it wants to. If it wants to affirm, doesn't want you to go any further. It's going to PCA, per curiam affirmed. Supreme Court, huh? DCA can shut it down anytime it wants to. Florida Supreme Court jurisdiction. Number 6 on the list, may, again, this is discretionary, may review a question of law certified by the Supreme Court of the United States or the U.S. Court of Appeals, which is determinative of the cause and for which there is no controlling precedent at the Supreme Court of Florida. You saw that happen in our last lecture. We were talking about Florida's Religious Freedom Restoration Act. And there was an unresolved question under that act, according to the good judges up there in Atlanta, Georgia, presiding over the United States Circuit Court for the 11th Circuit. So they, based on principles of comity, C-O-M-I-T-Y, not comity, but comity, I don't know how you pronounce this, I'll spell it, C-O-M-I-T-Y. Based on those principles, federal court isn't going to decide in instance of first impression as to what a state law means. So we've got a system set up. Florida's Constitution gives Florida Supreme Court jurisdiction so that it's Florida that is the ultimate arbiter of Florida law, assuming our good friends in the federal courts play along. Number 10, see it's in green, to remind you that I'm not stupid. See, we jumped from 6 to 10. What happened to the numbers in between 6 and 10? Well, 7, 8, 9.
But I'm bummed.
Yeah, Nick, perfect timing, buddy. Yes. I knew someone would laugh at that joke. Everyone, Nicholas should eat. Yes. All right. Nick, I was just bragging on you.
Well, continue.
There you go. And I should have a proper introduction dreamed up. I really should.
It's all, I don't want to stop you mid-sentence, please.
No, I'm stopping mid-sentence. I'm going through the list of enumerated jurisdictional bases of Florida Supreme Court. And somehow, many of these people are still awake.
Yes,
Some of them are still awake.
Bravo.
Right? They deserve the applause.
Yeah.
Yes.
What? Yes.
Yeah. Well, Nick has been a member of the Florida Bar for so long that his bar number lacks a digit.
It only has 4 numbers.
It only has 4 numbers in it. It's kind of like back in the day when you could dial someone on the phone with just 7 digits. Back when Nick got sworn in, you could just number the members of the bar.
We only had 3 numbers.
With 3.
But you used the string between the 2 tin cans.
Oh, is that why it's such a bad connection when we talk on the phone?
That's pretty much it.
There you go.
That's it. I'm always traveling through a tunnel. I don't know why that is.
And Nick is a beautiful man, and not just because of your first cases to me. Not just for that reason. Mostly for that reason, yeah. But Nick is board certified in appellate practice. Nick practices right here in Orlando, Florida. Nick is the former president of the Orange County Bar Association, a fine group, a group so fine that I've been meaning to join for years. Nick has done more pro bono work in 1 week than most of us have done in a year. And sometimes it's for a pro bono client, not just for a non-paying client. Although I help you with those non-payers anytime.
And I appreciate that.
Got your back, Nick.
Yes, you do.
Yes, got your back. But Nick is here because I know, even though we're on chapter 5, that you've been reading in your spare time chapter 14. Yes, chapter 14. Anyone here help me pay my mortgage by buying this book? Does anyone do that? Oh, thank you. I thank you. My mortgage company thanks you. My wife and kids thank you. Yeah, so please turn to page or chapter 14, page 501. Page 501. And here in academia, I say that as if I'm in academia more than just Thursday nights from 5:45 to 7:45.
It says professor on here somewhere. So.
Actually, no, I was careful not to do that. Yeah, I don't want to co-opt the title I did not earn. Yeah. Well, let's face it. I didn't earn it. Chapter 14 talks about elections and taxation. Everyone's 2 favorite topics. Yeah. So elections and taxation. And over there on page 501, I opened this riveting chapter by talking about Article 6 of Florida's Constitution that discusses suffrage and elections. Nick, you're the expert. What's suffrage?
That's what people do every time we have elections and we realize that we have just elected these people. Much suffrage occurs.
Much suffrage occurs. Now, as the regulation of Florida's elections, Article 7 provides, Section 1, all elections by the people shall be by direct and secret vote. General elections shall be determined by plurality of vote cast. Registration and election shall and political party functions may be regulated by law. However, the requirements for a candidate with no party affiliation or for a candidate of a minor party for placement of the candidate's name on a ballot shall be no greater than the requirements for a candidate of a party having the largest number of registered voters. And then I pose this question. Is the election process of any state more infamous than Florida's? In Bush versus Gore, quote, 7 justices of the Supreme Court of the United States agreed that there are constitutional problems with, end quote, Florida's election system. The U.S. Supreme Court held that in Florida, a simple recount, quote, this is high praise for our system here from SCOTUS, a simple recount, quote, cannot be conducted in compliance with the requirements of equal protection and due process without substantial additional work. Ouch. High praise for Florida's election system? No, not high praise for Florida's election. So then I ask, here we are more than a decade later, has Florida solved the infirmities in the regulation of its elections? And I asked you to consider a particular case, Orange County versus Zane? Zane. Now, how many times have I struggled with the proper pronunciation of a party to one of the cases I stuck in this book? You see me do it more than once, right? Right? Wouldn't it be nice if you could like grab the lawyer that represented that party, have him drop on by right in the middle of your election, just in time to laugh at one of your worst jokes, and could tell you about that case? Ladies and gentlemen, that's the kind of service I provide for you. That's why Nick Shanine is here tonight. Yeah. All right. So I should do a better introduction.
No. Yeah, that is, trust
Yeah.
me, more than anybody.
I could plug your website. Yeah. All right. Plug in the website. SHANNINLAW.com.
Got it memorized.
Got it
That's
memorized.
props to
There
this
you
guy
go.
right here.
Yeah, all right. And for how long have you had as a client the Orange County Supervisor of Elections?
I have represented Bill Cowles, your Orange County Supervisor of Elections, since 2010. So when Rick Scott first got elected to be governor, those primary and then general elections were my first times of serving him as his general counsel. And obviously he's had 2 terms and moved on to Washington. And so that all worked out great. So I've been there for now close to 10 years and might have some fun elections right around the corner. No litigation will happen at all, guaranteed.
So when it comes to Florida election law, who wants to hear from this guy? Say me. Me. Got a lot of me's. So with your permission, Nick,
Yes.
we always take a 10-minute break somewhere in this election.
This would be a wonderful time.
That's what I was thinking.
Yes.
Yes. So now that'll give me time to dream up some more jokes and throw into your introduction. Also give anybody who wants time to get a drink or something like that. Oh, I mean a non-alcoholic drink or something like that. Okay. And I'll see you back in 10 minutes.
All right.
Oh my God. People are gonna hear that and be like, oh. And I'm like literally.
I get to be a star on TV. Or whatever that is.
Yeah, my latest video, I think it's
Yeah. I'm gonna bump this up.
Oh,
We're gonna hit 11. Yeah.
I wanted to
The only time you're actually on screen is about from here to
Okay.
the end of the, because see, there's the
Why?
there you are.
Hi there.
Yeah, there you are.
When he was talking about Nick Shanine, that would be this guy. This guy right here. All right.
So there you go. Yeah.
Florida State Courts and Judiciary.
Yeah.
See, next time I'll know. I'll like PowerPoint it or something so we can pop up
Oh,
some.
how much slides did you want? Yeah. I'd like to say they got better on here. I don't know. I go with that stunning color scheme with black and white.
You know, well, a little bit of green. A little bit of green. Can't go wrong there.
Man, thanks for doing it.
I'm glad it worked out because I was worried. Oh no, I'm gonna get too late. But it's like, no, I got here.
Did you navigate through the
I did.
campus?
Your directions were actually great. I did. I didn't want to run the circle. And I'm like, okay, I see you parking on dirt.
Yeah.
Let's go do something. Here, I just made a guess where to park, and I think I parked right behind, the door that's
Oh, that's
not
sweet.
an exit.
You could do that. You could do it.
Yeah.
Yeah, I don't think they can arrest you.
Oh, it is an exit.
Doors exit only. Oh, there you go.
So I
See, they're walking out.
That's not a good sign.
So it's a little bit of a walk for Kobe. Walmart.
Good. No? Yeah, I brought my own beverage. I can't compare it.
Yeah.
BYOB. And, but I'll pay to privacy.
Okay, let's make.
Yeah, I mean,
I got a map of Florida. Oh, here's the extraordinary rates.
actually, tell you what, you can leave it on,
Extraordinary guy.
on quo warranto, because I might, if I have time, I'll get to that.
Oh, you will?
Yeah, why not? I mean, only if we have time, but I think we will. I can't talk about this case for now.
Mandamus, prohibition, quo warranto.
Yeah, I don't know if we can leave it up on that the whole time, but yeah, we can. We gotta leave it up on something, so why not? Yeah.
It's type on. You want me to type on the slide?
This one. But yeah, does that make it into the,
Oh,
Yes, it
I hope
does.
so.
ShanimLaw.com. It's backwards, but
well, it's only back from our perspective. I hope.
okay.
I haven't actually watched these videos, but I presume they're not backward when they're on the YouTube. I presume. Wow, two good-looking guys.
Yeah, I think so.
Yeah, I like your type better.
I know. I wonder because it's. I mean, you would think you think it has to be flipped the right way, but it does.
It's gotta be flipped around. I hope so. These videos are gonna be awkward if it's not.
Have you not looked at it?
No.
Because, well, I don't either. Whenever I do videos, it's like I just assume it came out and we leave it.
Yeah.
I'll be your ATM.
Thanks. Yeah. Oh, I never tried to watch it. I presume that's why it's I called it Florida State Courts Extraordinary Rates.
Okay, what is it? Excuse me. Yeah, you want to have the story?
Why do I miss all of this stuff?
That's it.
And there it is. And there we are. We are watching ourselves watching ourselves.
Oh, this is
Actually-
this is sci-fi.
No, okay, it's a little
This
bit in the past, so we're
No,
not
it's
quite watching, but in the future we will be watching ourselves. Now, oops, come back. Okay, so. wait, I tried to.
I didn't know you could do that.
See, there I am scrolling. Okay, there. Yep.
This is
so,
I'm waiting. Not yet.
and so in the future, so.
Not yet. Oh, there you go.
Yeah, so
it's
now
like
you
a
know your
5-second
lag.
delay, maybe.
Now you know your lag.
Oh, is there a 5-second delay for like if someone like would have cussed or something? You could bleep it. Is that what it is?
I don't think so. That is why stations have a 7-second lag. But that
Hey,
is-
maybe you could do FCC law next week.
This is the actual time it takes to get it here, to get it there, to get it there, to get it there, and back to here again. But yeah.
But I'll pause for you. Oh, the attendance sheet. I don't know how your local law school was. Mine didn't start required attendance about halfway through. Honestly.
Well, it's interesting because it's an ABA thing. That in order to accredit the law school, you have to have,
Oh, they have to have required.
you have to have required attendance. So even though undergrad could care less whether you show
Thank
up or
you for the
not,
sheet.
law school
Thank you.
cares. And so even back in the day, they did do it, but we didn't do a sign-up sheet like that. Instead, the teacher had, her, list
Well,
of the
that's a
students,
teacher
and then
who
you could do the
shows up far enough in
Hausman
advance
thing.
to pick up the shit.
Yes. No,
Mine's
but
waiting for me.
no, okay. Well, but I'm going to presume that they are not assigned seat.
No.
See, and
That's
this,
an option.
right.
but I don't-
Back in the day, there was not an option. You choose one seat at the beginning of the semester, and that is where you shall stay. And there were two reasons for that. The one was just because it was fun and neat. But the other was that way they didn't have to send out the sheets. The teacher could simply look at the thing, go X, X, X.
All right, so this is good reason for it.
And then when they made fun of you for being late, that was both, again, to be mean, but also because now they were pointing out the fact that, hey, don't be late because you'll show up as absent on this and we lose our accreditation if not enough people are not coming to courses. that accreditation might have been a pretty big deal for a while. So I was good friends with one of the Walking Down. So oh yeah, you can take the test. We can't tell you if you're going to be able to get your test results, but you can take it. And he took it, and he took it, and no results for him the first time around. And they had to sue, and yeah, it was a big mess. But
I just wouldn't have taken it.
well, and the number didn't, but number were, well, I don't want to wait and take it later. I want to take it now because I know it now. So let's roll the dice. Rolls your dice, take your chances. Soy boy.
So what else can I do? Make
Nah, we're good. We're good. I'll move my stuff over here.
Okay, yeah, move my stuff out of here. What day? 7, 8, 9.
As soon as I heard the numbers between 6 and 10, it's like, oh my God, is he really going to drop the 7, 8, 9? And then there it was.
That's the best joke I have of the whole semester. 7, 8, 9. It doesn't get it. Have you heard a better joke than that? You have not.
Has he given you your grades
Best I
yet?
got.
If he's not giving you your grades yet, the answer is no, that is the best joke I've ever heard.
Admitted all my jokes are terrible.
I'm not gonna admit or deny anything.
That's right.
The George Washington line works there.
There's microphones. You want one?
But, I mean, if you've not been using one, then I'm not.
I usually do. I just forgot it this week. I mean, this week. This lecture. Yeah.
Opinion. Yes. They look identical. Except for the fact that this one goes this way and that one goes that way. Well, that too. So it shows you I'm not printing out.
Oh, wait a minute. So there was a prior opinion that they yanked?
Your book only has half the story.
I can't wait to hear the story.
That's a good story.
Yeah, because that's a trial edition of the book that a publisher's actually working on.
I saw that trial edition.
Yeah, and they'll let me change up to 10% without charging.
Back. Yes. Yeah. No, you need it back.
Okay.
Yeah.
They'll let me change up to 10% of it without charging me anything, or
Right.
they charge me if it changed more than 10%. But if regardless of the charges, if there's something great to add, I'm going to add it.
Well, it would be good to add only from a jurisprudential aspect. It's useless to add it from a legal standpoint, in as much as this is the law, this is not.
Yeah.
This is obiter dictum,
Oh, Latin.
Yes, that is what it is. But if this class, we're not called Florida constitutional law, but we're called jurisprudence, then it holds, you'd want this opinion and that opinion to both opinion, because you could do a course on that.
Huh. Yeah.
It's kind of crazy.
Oh, was this one of the ones where the new judge took the bench and they called back?
Yes.
I didn't even realize that.
But yeah, that's
Okay.
this was the
Oh,
first
no,
one.
you gotta cover that. This is the first one?
This was
So
the-
people were saying, what?
Well, thank you. Except for this guy.
I can't wait to hear this. I'm gonna take a seat.
Yeah.
Unless you want me up here, come, Joe.
You will.
No.
After they heard I was coming.
His attitude brought him back. But I'm gonna get some.
Yeah, no, that's a good call. Actually, you know what? I'm gonna follow you.
Me.
Oh, I know.
Where are you going?
Julie, what temperature do you keep your house? Yeah, she's awesome.
I really would wake up in hell. Like, I think that's what would happen to me.
It's like 73 in my house, and I wake up and it's.
Mine came out at 68. When mine's at 72, I can feel, I know it's up. And I'm like, it's hot. He's like, no, it's fine. And I look at the thermostat. It's at 72. I'm like, that's why. I really, how do you, like, laugh and, like, move? Wouldn't you start getting hot?
You sweat a lot.
That's what he tells